su nombre completo aquí. Sí. En la primera.
Do this here. Again, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. As I said earlier, you were asked to come here for what we call an arraignment. An arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are referred to as your more serious type of criminal offenses. However, your misdemeanor cases are referred to as petty offenses. It does not mean that they're not serious. They're just not as serious as a felony offense. If you had a felony offense, the case could either be a capital murder, first-degree felony, second-degree felony, third-degree felony, or a state jail felony. For a misdemeanor offense, you either have a Class A misdemeanor, Class B misdemeanor, or a Class C misdemeanor. Now, for your felony cases, the range of punishment may entail that you be sent to the state penitentiary. For example, if you have a capital murder, if you're found guilty and you're convicted, then your punishment either could be life or death. If you have a first-degree felony and convicted, then the range of punishment is 5 to 99 years to life, fine up to $10,000. For a second-degree felony, the range of punishment is 2 to 20 years, fine up to $10,000. For a third-degree felony, the range of punishment is 2 to 10 years, fine up to $10,000. And for a state jail felony, the range of punishment is a minimum of 6 months to a maximum of 2 years in the state jail, fine up to $10,000. Now, for a misdemeanor case, a case that you're charged with, you cannot be sent to the state penitentiary. However, your punishment can entail that you be sent to the county jail if you have a Class A or Class B misdemeanor. Now, if you have a Class C misdemeanor, the range of punishment is fine only. That simply means that you cannot be given jail time. You only could be given a fine. Now, normally in County Court at Law number 2, we handle Class A and B misdemeanors. Okay, again, ladies and gentlemen, as I was saying, misdemeanors are divided into Class A, B, and C misdemeanors. For Class C misdemeanors, only is fine only. You only could be given a fine. Now, in this court, we normally handle Class A and B misdemeanors. Your Class C misdemeanors are handled in the city court, or which is called municipal court, or the JP court, which is the Justice of Peace Court. And what that basically means is we only get those cases, the class C misdemeanors, when they are appealed. For example, you're found guilty in municipal court or JP court, and then you say, well, I want to appeal my case, then the case comes up to us. And once it comes here, we still cannot give you jail time because the punishment range only require that we give you a fine only. Now, if you have a class A misdemeanor, that's our highest misdemeanor. The range of punishment is anywhere from a minimum of 0 days to a maximum of 365 days, which is a year, or you could be given a fine from $0 to $4,000 or anywhere in between, or you could be given both just fine and confinement. If you have a class B misdemeanor, the range of punishment is anywhere from 0 days to 180 days, which is 6 months, or anywhere in between, a fine from $0 to $2,000 or anywhere in between, or you could be given both such fine and confinement. Now, you may qualify for what we call probation. There are 2 types of probation. One type of probation is adjudicated probation. We normally refer to it as regular probation. Adjudicated probation actually results in a conviction in your record. Now, the other type of probation is called unadjudicated probation or deferred probation. Now, that does not result in a conviction on your record. Now, if you get deferred adjudicated probation and you successfully complete the probation, you will not have a conviction, your case will be dismissed, and you may qualify for what we call a non-disclosure. What a non-disclosure is, it simply means that we cannot disclose or tell the general public that you were on deferred adjudication for this offense. However, if you violate your unadjudicated probation, then the state, that is the district attorney's office, can file a motion to revoke your unadjudicated probation. And if that is done, then a warrant could be issued for your arrest. You could be arrested, put in Jefferson County Jail. Obviously, you'll have a right to bond out. You'll also be entitled to have a hearing to see whether or not you have violated your probation. Now, if the court determines that your probation has been that you have violated your probation, then the court can either keep you on probation, the court can revoke your probation, amend and extend your probation. But in any event, if your probation is revoked, then you cannot get your case dismissed and you cannot qualify for a non-disclosure. That's for deferred adjudication. Now, with the regular probation or adjudicated probation, as I said earlier, it does result in a conviction on your record as soon as you get on it. However, there's something that is called judicial clemency. Judicial clemency means that the court or the judge can set aside your conviction. And that simply means that the court sets aside your conviction, you will no longer have a conviction on your record. Now, in order for that to happen, first of all, you have to successfully complete the probation. The next thing is your probation, the time on your probation has to expire. You cannot have any more time on your probation. And then the court has to discharge you off of the probation, which means the court can allow you to get off the probation. And if that happens, then any complaint affidavit or information that has been filed against you will be dismissed, and you will no longer have this on your record as a conviction. And so therefore you can successfully say or truthfully say that you have not been convicted of this offense. However, if you get a subsequent offense, or if you get an offense, another offense later on, or another conviction later on, then this case can be used against you. And it could be resurrected, revived, and brought back up, and it could be used against you. If you try to get a license with CPS, they could revoke your license if you have one, or they could suspend the license, or they could deny you from even getting a license. Now, you as a defendant have rights. One of the rights that you have is you have a right to have an attorney. That is, you have the right to have an attorney to represent you. Now, you have three options with regards to having an attorney. First of all, you may hire an attorney. Now, if you cannot hire an attorney, if you do not have the money to hire an attorney, you may qualify for what is called a court-appointed attorney. An attorney could be appointed to represent you, or you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset to give you time to do so. If you want an attorney, but you do not have the money to hire an attorney, then you will have to fill out a financial affidavit to see whether or not you qualify for an attorney to be appointed to represent you. You may not speak to the prosecutor, that is the assistant district attorney, about your case unless you first sign a waiver of your right to be represented by an attorney. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, you'll be given a form with this information that I just read to you. And at the bottom of that form, it states that defendant's choice. Mark initials next to only one choice. Now, if you want an attorney, if you want to hire an attorney, you'll put your initials on the first line. If you've already hired an attorney, then you'll put your initials on the second line and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you'll put your initials on the third line to the left. And if you've already been appointed a court-appointed attorney, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. And the last choice is if you want to waive your right to an attorney and represent yourself, then you'll put your initials on the fifth line or the last line to the left. And then you'll sign the bottom of this document where it says defendants, and then you'll date it today's date, and the day's date is January 4th of 2021, excuse me, of 2022. Now, ladies and gentlemen, you also have a right to have a trial by jury. That area over there where you see those individuals sitting, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your jury. And at the end of listening to all of the evidence, they will decide whether or not you are guilty or innocent. Now, you also have a right to waive your right to a jury, which means you have a right to give up your right to a jury. And by doing so, you will not be having a jury trial. And because you waive your right to have a jury trial, then your case will come before the court or before the judge, either by a trial, and that trial we call it a bench trial, or it could come before the judge by way of what we call a plea. Now, a bench trial, as I said earlier, is just a trial before the judge. And the judge is a judge and the jury. And it basically, and the judge, if the judge can find you guilty or not guilty, and if the judge finds you guilty, the judge will also assess punishment. Now, I also said that your case could come before the judge by way of a plea. What a plea is this. You have an option in your case to plead not guilty. Not guilty. If you plead not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can plead guilty. If you plead guilty, you're telling the court that you committed the offense that you've been charged with. Or you can plead no contest. And if you plead no contest, you're telling the court that you will not be fighting or you will not be contesting those charges. So in order for your case to come before the court, by way of a plea, you'll be entering a plea of no contest or guilty. And then your case comes before the judge. Now, before your case comes before the judge on a plea, you'll have an opportunity to talk to the prosecutors to see if you can work out a settlement on your case, to see if you can work out a plea bargain. That's what we call a settlement if you're trying to settle your case. And if you are able to work out a plea bargain with the state, your case comes before the judge doesn't have to follow the plea bargain agreement, but if the judge follows the plea bargain agreement, then your case comes before the judge. Now, if the judge follows your plea bargain agreement and you decide, hey, I want to appeal, then you have to get permission from the court or from the judge to appeal your case. Now, if you do not have a plea bargain agreement with the state or with the district attorney, and you still want your case to come before the judge, we call that an unagreed plea bargain. And then the judge will decide what the punishment will be. Okay, at that point, you don't have an agreement, so the judge will say what the punishment is going to be. Now, the next thing is you have a right to have witnesses to come to court. And what witnesses do, they can testify for you or against you. If you or your attorney, if you're representing yourself, then you could ask them questions. If you have an attorney, the attorney can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses come before the court. And by doing so, you will not be calling witnesses. However, the state will be calling witnesses in your case that they have filed against you. Now, you also have a right against what we call self-incrimination. I know sometimes people look at television and they hear somebody saying, I'm gonna take the fifth. Well, what they're saying is, I'm exercising my Fifth Amendment right against self-incrimination. In essence, you have a right not to testify in your case, and the state or nobody else can force you to testify. Now, you also have a right to waive or give up that Fifth Amendment right against self-incrimination, which means that you can say, well, I want to testify, waive my right. I know I have a right not to testify, but I want to testify. So you'll be waiving, you have a right to waive or give up your right and testify in your case. You also have a right to see the evidence. We call that, you have a right to have discovery. What I mean by seeing the evidence that the state has against you. If they have videos, if they have witness statements, all of these things, whatever documents or whatever they have as evidence against you, fingerprints and whatever, you have a right to have access to that evidence. Now, your attorney, if you're represented by your attorney will have access to that evidence. Now, Jefferson County has a program for first-time offenders. That program is called a pretrial diversion program. And what that means for first-time offenders, they will dismiss your case. And if you successfully, once you get in the program, you successfully complete the program, you can get it expunged from your record. Expunged means wiped off, deleted, or erased from your criminal history. And in order to qualify for that, it has to be your first offense. You can't have a criminal history. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And you have to get an attorney to assist you to get into the pretrial diversion program. Now, if you are a veteran, if you're a veteran of any one of the branches of the United States military, you may qualify for what is called Veterans Court. With Veterans Court, as part of the pretrial diversion program, that simply means that your case will be dismissed, you complete the program, and you can get it expunged from your record. And I think only qualification to get into that program is being a veteran. So if you're a veteran of any one of the branches of the United States military, then you may qualify for Veterans Court. Now, everyone in here, you're here for arraignment, and that's because you've been arrested on your charge, and you're out on bond, and this is your first court appearance on this case. Now, every day that you spent in jail you can get credit on that toward your punishments. So for example, let's say you and the district attorney has worked out a plea bargain agreement. Y'all settled your case, you say it's 5 days in jail. And you've already spent 5 days in jail. That simply means you won't have to spend any more time in jail because you'll be given credit for the 5 days that you've already served. Now, if they say 6 days in jail, you did 5, that means you have to do 1 day in jail. Now, let's say the state, now every day that you spent in jail also is credited as $100 per day that can go towards your fine and your court costs. And so, for example, let's say the state you and the state has entered into a plea bargain agreement, and they say, okay, we're going to give you, your punishment is a fine plus court costs of $500. And so you spent 5 days in jail. 5 days in jail is $500. That means you won't have to pay any more money toward the fine and court costs because the time you spent in jail has already paid it off, and therefore the fine and court costs will be taxed and retired. Now, if they say fine and court costs of $600, you spent 5 days in jail, that means you will have to pay $100. Now, if you cannot pay the $100, then we could put you on what is called a payment plan. We can allow you to pay it in installments. But let's say you cannot pay it off in installments because you do not have a job, you do not have no source of income. Then the law allows us to give you what is called community service. That means you can work it off. Now, you get $12.50 for every hour that you do in community service. So if you work 8 hours, that's $100. If you work 8 hours in 1 day or whatever, that's $100. Now, this court has a program that is called the Community Safety Initiative. The Community Safety Initiative, which is we call it the CSI program. And it's a program that is designed to make Jefferson County a safer place for all of us to work, live, go to school, raise our families, go to church. And the way the program works is we address the issue of what is called recidivism. Recidivism means, well, people commit crimes over and over. So to prevent that or to address that, we have the Community Safety Initiative. That program was started in March of 2017, within 100 days after I started office. In that program, we have partnerships. We have a partnership with Spindletop, the Spindletop Center. Spindletop is our local mental health center. And they have a mental health program as well as a drug and alcohol recovery program. With the mental health program, we have individuals who are in court. They can do private interviews in the back, and Spindletop can develop a treatment plan after they do an assessment, and they can the treatment plan could be either outpatient or inpatient, depending on the needs that you have that needs to be addressed. Now, if you have an issue with drugs or alcohol, Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. That program, with that program, you can get an assessment. People can interview you. They can develop a treatment plan, either outpatient or inpatient. They have a program for youth. That's 21 years old or younger. And if you're older than 21, you can be interviewed by OZAR, which is our local our local drug and alcohol council. They can do screenings, they can do interviews, and they can develop a treatment plan for you as well. The other thing is, if you are unemployed, or if you're in a job that you want to get a better career, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program. With that program, you are trained in the areas, you'll be given training in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in one of those areas, they will assist you at getting a job. Now, if you have not graduated from high school and you do not have your high school diploma, no problem, because CICE has a program where you can get your GED. And so all of these programs that I just spoke about do not cost you anything. They are free. Does not cost the county anything. They're free. Only thing you have to do is have a desire to be in the program. Now, I tell people this all the time. When you come to County Court at Law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And we're trying to make a difference in Jefferson County by making Jefferson County a safer place for all of us to work, live, go to school, raise our children, and go to church. Now, the other thing is with our program, in County Court at Law number 2, we don't just give time. We take our time. In essence, we don't just arrest the problem, we address the problem. And so, and by doing so, we believe we can make productive people. And we believe that productive people do not commit offenses because they have too much to lose. And so if you're interested in one of those programs, just please feel free to let us know. We're going to have each one of you to come up one at a time when we eventually go through your case, and you can just let us know if you're interested in the program. Now, we have, as I mentioned earlier, we have folks in here from Spindletop Center. They're sitting in the jury box, and we're going to have Deputy Hinton to come up before you. He can tell you something about the services that Spindletop can provide for you and or your family members. So at this time, we have Deputy Hinton.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I am the mental health deputy licensed by the state of Texas. I'm here with my partner. He is a qualified mental health professional. Here today, the judge cares about every single person that comes before his courtroom. Now, what the judge has found over time is people who come to his courtroom commonly have mental health issues or substance use disorders. And he believes, which Spindletop also believes, that if we can address some of these underlying issues, we can get you out of the cycle of arrest. If in fact this applies to you, what happens if you don't get help and you have some of these or you suffer from some of these issues? You'll graduate to the felony court, which is next to us, and eventually in 5 years, you'll be the ones down there in the county jail that are kind of stuck in the system in the process. So we want to offer you an option. We want to offer you services to get you out of that cycle of arrest. But it's going to take a bold step from y'all to make that decision to reach out to us. We're willing to visit with y'all, and as the courtroom goes into recess, we will be visiting with you individually. If nothing else, I want to get this brochure in your hands because it has a 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. There's also another number for the office. Should you want help, we can help you even outside the courtroom. But we're here today to help you. If you'll reach out to us, we'll be glad to visit with you privately. Your information is not public. It is HIPAA regulated. We're not here to embarrass anyone, but we are here to help each and every one here that wants help. Now, maybe this doesn't apply to you. Maybe it applies to a family member. If it does, we would be glad and honored to help you get the information to bring back to your loved one so that you can help them and provide the services and options to them, at least the opportunity anyway. Does anyone have any questions? Thank you all very much. You're very kind. Thank you, Your Honor.
All right, thank you, Deputy Hinton. Now, ladies and gentlemen, our court staff is going to pass out some information, some forms to you, the ones that I mentioned earlier. They're going to be on a clipboard. One of them is called Judge Explanation of Defendants of Rights to Defendants Without an Attorney, and you'll read through that. I went over it already with you, and you'll make your choice at the bottom where it stays, 1 through 5, whether or not you want to hire an attorney, whether or not you want to put upon an attorney, whether or not you want to represent yourself. And if you are representing yourself, then you would have to sign a waiver of counsel. That would be the second page, okay? Now, this is gonna take a little time. Our court staff is gonna be happy to help you. If you need any assistance, please let the staff know, and they'll be happy to assist you with filling out those forms, okay? So this is gonna take a little time. Now, once you finish filling out the forms, if you wanna step out into the hallway, you can, but do not leave the courthouse, because if you leave the courthouse, your bond may be forfeited and a warrant will be issued for your arrest, okay? So this is gonna take a little time, so just be a little patient with us. And again, I'd like to thank you for your time and your attention, and at this time, the court will be in recess.